Hi, my name is Russ Weninger. I'm a lawyer at Weninger Jong. Today I'm going to talk about what joint ownership means. Joint ownership is a special type of co-ownership that's typically reserved for spouses, common law partners, and occasionally other family members. While joint ownership is a type of co-ownership, not all co-ownership is joint ownership. Joint ownership has a very specific legal consequence known as the right of survivorship. The right of survivorship means that if one of the joint owners dies, the survivor then becomes the sole owner of the property in question. Joint ownership has an important effect on estate planning because it means, usually, that a co-owned asset that would ordinarily form part of a deceased person's estate will not, in fact, form part of that person's estate if that person is the first co-owner to die. It will, however, form part of the estate of the surviving co-owner, assuming that person doesn't transfer or otherwise dispose of the property prior to death. Now, there are some exceptions to this principle, especially involving joint ownership of property for parents and children, but I won't get into those exceptions here. If you're curious about the exceptions, please check out the Pecor case from the Supreme Court of Canada. And I'm not sure about the pronunciation, but it's spelled Pecore, and it's a case from 2007 from the Supreme Court of Canada. Joint ownership can be an effective estate planning tool for married and common law couples because it allows for the transfer of property upon death outside of a will. And it helps the survivor to avoid the probate process, at least for that particular asset that is jointly owned. It essentially provides a quicker, more efficient, and less expensive means of transferring property upon death from a deceased spouse or partner to a surviving spouse or partner. Now, while joint ownership can be useful for spouses and common law partners, we usually wouldn't recommend it as a form of ownership to be used by two business partners or two siblings or a parent and child. Business partners usually want their business assets to go to their respective family members, or alternatively, they want their surviving business partners to buy out the deceased partner's share from the deceased partner's estate so that the deceased partner's family members will benefit from the asset. Siblings, likewise, usually want their individual shares in a co-owned asset to go to their respective spouses or children. In the case of a parent owning property jointly with a child, the parent is likely to die before the child, and if the jointly held asset is a significant asset, the practical effect can be that other surviving children are essentially disinherited. This is one of the reasons why the Supreme Court of Canada modified the effect of joint ownership in certain circumstances in the Pecor case referred to earlier. Now, for business partners, siblings, and parents and children, there are other forms of ownership that can be employed. For example, real estate can be held through a type of co-ownership known as tenancy in common that doesn't involve the right of survivorship. With ownership through tenancy in common, if one of the co-owners dies, that person's estate retains ownership of that person's share of the property. Business partners may also wish to consider holding assets through a holding company. In using such a strategy, each partner will have a certain number of shares in a holding company, which in turn will own an asset, such as a piece of land. Joint ownership can definitely be an effective estate planning tool for spouses and common law partners. For other family members and for business partners, consider holding property through tenancy in common or through a holding company. If you have any questions or comments, feel free to leave them in the comment section. Thank you for watching.